Hey everyone, welcome to this week's edition of Skills. Sorry it's a little late today. Having some technical issues. For some reason we didn't have connection at first, then it was just got crazy. Hold on. Yeah, and on top of that, now you heard me talking in the background because I'm looking at this side chat. But as always, today we're going to be looking at hearsay and policy. I've gotten a couple questions from a couple of students just about hearsay and policy. And let me present this real quick. So, what's been going on is that a couple of students came to me last week and asked me about policy when it comes to hearsay, because in our rule explanation, just as we did for the midterm, what we do is we get a set of facts. Let's say for I'm thinking about what rule was that? That was subsequent remedial measures, and we would see whether in a 403 analysis whether the action that occurred, whether it furthers a policy of not holding people liable for repairing something, or whether it hurt the policy, or whether the jury would use it for a reason like culpability, which the rule kind of suggests that you shouldn't. So using policy to strengthen your argument, to say, the judge should rule in our favor because it either forwards the policy of not holding people liable for repairing something that's broken, or for the jury may be using it to say that the person who fixed it is liable. So that was always like the balance between the policy and using the rule. So the professor has been telling us about policy for hearsay. And a couple of students, again, like last week, they had mentioned that they understood some of the policy implications of hearsay, but they wanted just to get something a little bit more formalized. So what I'm going to do today is present the general policy for hearsay, what the policy concerns are for hearsay in general, and then we'll go into some examples, and then we'll look at present sense impression and excited utterance and the policy concerns for those, because those are a little bit more specific. And then at the end, I'll give you a couple of other hearsay exceptions that we've gone over, and hopefully you'll be able to look up the policy yourself. And then next week we'll come back and I'll release the document that actually has the policies for each of the specific hearsay exceptions listed. So let's get into today's PowerPoint. And as you can see, the first thing says hearsay. So since we're talking about hearsay policy, the first thing when we talk about policy for hearsay is just reliability. Generally, hearsay statements are not reliable. They are statements made by, it's an out-of-court statement offered for the truth of the matter asserted. It's statements made by people who are not testifying in court at that time. And that reliability piece is what the court and what society is trying to evade. So let's look at some of how reliability relates to hearsay. So when we talk about policy for hearsay, the first thing we're going to talk about, and again, this list is going to be directly from the Professor Valentine's slides. The first policy exception, the first issue that deals with reliability is the risk of error. And that is the telephone game. I don't know if when you guys were younger, if you guys remember the telephone game, you'd have a line of maybe 10 people, and you tell one person, the first person, something, and each person tells someone else until it gets to the end. And very few times the person at the end said the same thing that the person at the beginning said. So there's a high risk of error when you're talking about relaying information from someone else that you don't have personal knowledge of. And that's one of the policy reasons that hearsay is not allowed in court. And again, it's about reliability. How do we know it's reliable? Second reason is the juries aren't able to assess credibility because the declarant is not in court. And if you think about it, let's say we have the example where you have the declarant, and the declarant's on the stand, not the declarant, the witness on the stand that says, John told me it was raining outside. Well, there's no way the jury can assess John's credibility because John is not in court. Only person that you have up there is a person who's heard that statement. You can assess their credibility, but again, there's no way the jury can actually know if that John is lying, is he sweating, how is he actually saying the statement. So the jury loses that ability to see if this person who's actually made this statement is credible or not. And if that's the case, then it takes away the ability of the jury to then say, yeah, we can rely on this statement as truth because we don't know if the person is a credible witness. Next policy determination would be about cross-examining. The declarant can't be cross-examined, and that's really about we're really talking about the confrontation clause when we're talking about cross-examination. But if you're if a statement is made that's going to be detrimental to someone's case, then you should be able to cross-examine the person and say, well, if we go back to our example about raining, if the person says, well, how did you know it was raining? Were you wearing, were you outside? Did you get wet? Did you hear it from someone else? How do you know it's raining? That cross-examination, even though it may be fruitless, it does give you a chance to determine whether the person experienced what they experienced and to be able to push back a little bit. And not being able to do that would be a problem. Open formality. Now, this is interesting because you can think about it this way in our example of the rain, of John told me it's raining outside. John didn't take the oath. So there's, even if John was lying, it's not like he's going to go to jail. Then we're not going to charge him with perjury. And again, the person who actually is repeating the statement, they've taken the oath. They're 100% telling the truth that John told them that. But that doesn't tell us whether that statement is true, whether it was actually raining outside or not. And that's one of the big issues when you're talking about oath and formality. And again, this witness that's on the stand is taking the oath, but John, could be lying, and there would be no repercussions if John was lying. Also, there's no personal knowledge. So, for instance, FRE 602 says witnesses have to have personal knowledge, but the witness only testifying as to what the declarant alleges, what John says. They had no personal knowledge, not testifying as a witness, personal knowledge. So again, the person who's on the stand doesn't have personal knowledge of what actually happened. And since they don't have personal knowledge, this does seem to violate Rule 602, but then also makes it less reliable, just like not taking the oath makes it less reliable, not being able to cross-examine. So again, this is just another form of whether this statement, the court and the jury can trust the statement as being reliable. Because again, the person who's actually saying it doesn't have personal knowledge. And for 403, the overreaching concern is the jury misusing the statement. So if you were to allow a hearsay statement and you had to do a 403 analysis, the prejudice that you're talking about is the jury misusing the out-of-court statement as true. So in our example of John saying it's raining outside, and it happens to be a hearsay statement, the jury could misuse it and say, well, it was actually raining outside because, John told this witness. And that would be unfair. That would be a high degree of unfair prejudice because they would be at that point using it for the truth of the matter asserted, which can happen. And again, with this 403 determination, you saw that with other rules too, as for instance, subsequent remedial measures, where you're using it to prove ownership or control. But then you look back and the jury says, well, then they're culpable because that would be the jury misusing the subsequent remedial measure for culpability and not for control. And that's what the 403 balancing test is. So you don't want the jury to misuse this statement. So now, what we looked at before, or in this slide, we're looking at just the general policy against hearsay. We're looking at the reasons why most of these hearsay statements are not reliable or are considered not reliable by the court. And all these things, determine that even though hearsay statements can be reliable, but it's likely not to be, and those are the reasons why they won't be. So now we go from the general to the specific, and the specific is each particular hearsay exception, when you do allow hearsay in, is going to have its own rationale for why that exception overcomes the reliability issues of just general hearsay. So here are the reliability issues of general hearsay. And for prejudice impression and excited utterance, these are the two that we learned, I believe, the week before last. This will help us understand for these particular exceptions why the court allows them to overcome these reliability issues that we just looked at. So, for both presence impression and excited utterance, um, as a refresher, presence impression describes an event as it's happening, and an excited utterance are statements in response to startling events. You become a recorder. Oh my God, the guy has a gun. He's pointing the gun. Presence impression. You're describing these events as it happens. So all of these things, and they're very, even though they're very similar, there are differences. But that's what we're talking about. We're talking about the person, in one instance, under the stress of an event, and the other sense, the other person describing it as it happens. So look at this. The policy for both of these exceptions are very similar because there's a lack of time to fabricate. And what do we mean by that? Well, because, if you're describing an event as it's actually happening, or you're under the influence of the startling event as it's actually happening, then this lack of time to fabricate, it doesn't give you that reflection time. So the court thinks and society thinks that makes that statement more reliable because it's not like you're thinking about what to say. You just become like a tape recorder or a video camera. You're just repeating what you've actually seen. That gives you a leg up on reliability. These statements are more reliable because of this. Accuracy, not relying on memory for the statement. Again, you're now becoming like a video camera. There's no memory. You're just telling people what you saw. You're just repeating what you've heard directly. So that also seems to counteract the reliability issues of hearsay and sincerity. Hard to come up with a lie as events are unfolding under the stress of an event. So here you have three reasons why these exceptions would allow hearsay in for the truth of the matter asserted. Where on the other piece, you would generally won't allow hearsay in because of those reliability issues. So when you're thinking about just hearsay generally, you think about why it wouldn't be reliable, and you can list any one of these issues from this slide to help your argument, your policy argument. But here, specifically, want to first explain why hearsay is generally not reliable through one of these forms, and then you want to go into specific reasons why this particular form of hearsay, presence impression outside of others, may be reliable. And this is very important with your balancing test too, because in your balancing test, you're going to have to explain on one side, yeah, there's an unfair prejudice for this coming in for the truth of the matter asserted because it's unreliable. But on the other side, you're going to say, well, these statements are a little bit more reliable because of these policy issues, lack of time to fabricate, tend to be more accurate, and you tend to have sincerity with these statements. And again, these shouldn't really be long, drawn out explanations, but just understanding why these statements are considered more reliable than just hearsay statements is very important. Now, these are the four hearsay exceptions that we have talked about recently. Recently, last week. And for each one of these, think about this question. Why are these more reliable than hearsay? Why is it more reliable when it's a then existing state of mind? And hearsay is being offered for a condition and medical treatment. Hearsay within hearsay, or even business records. When these exceptions are overcome, you always want to think about why are these more reliable than just regular hearsay. And when you start thinking about it in that way, you'll start seeing how each one of these exceptions and how the policy forwards it. Like, for instance, we even take business records, and for a company, every time this particular event happens, they create this report. Then that makes it more reliable because this is something that you're doing in the course of business versus this is some special event that you want to, write down a report for. That's a different story. So again, look at each one of these and then determine, why are these more reliable? Because that's what you're talking about when you're really talking about hearsay. Understanding why we're going to take these statements as more reliable than hearsay statements. Now, I would like to do one thing before we go. 1 second. Let me stop screen sharing. Oops. So first, before we go, I want to see if there's anybody has any questions in the live chat. I know this was a little bit this was a little quicker than we usually go. Um, just for everybody, Friday I put out the rules for family law this week for the upcoming week. Seemed to be very successful for last week. So if you're, if you want to see the preview of family law rules for this week, I sent out an email and there's a video up about that. This policy for the evidence piece, I think, is really important because, again, I think you have to understand not only why it helps you understand why hearsay is not generally allowed, and then these exceptions help you understand why they overcome the reliability issues with hearsay. So again, I want to thank you guys for watching, and I don't really have any questions. And it's funny because when I do these slides, I usually try to build in some time for questions and answers. But it seems like everybody's getting it. Now, going forward in the semester, there are a couple of things I do want to mention. First, we're going to still be doing skills on Sundays at about 2 o'clock. Unforeseen issues with internet issues, but generally we're going to be doing it this time. If you guys want to join, you'll be more than happy to. Also, we're going to be doing exam reviews coming up soon, so I've been asking the professors to start giving me old exams. And as they'll start coming in, I'm going to start putting in questions, doing those live questions, and we're going to be looking at particular IRACs and things of that nature, and how the professor wants to see an IRAC, and how a professor is looking at the evaluations of these questions. So we'll be doing that real soon. Next week, in skills, we're going to specifically look at constructs. And we're going to look at the way constructs is being put together, and we're going to really focus in on how to create a proper analysis for constructs, because it's very similar to evidence, but the professor in constructs, Gomez Velez, wants something very specific, and there's a process in which he's trying to point you to evaluate the questions on the exam. So I want to just state that clearly what that is. I want to give you examples of how to do it, and hopefully you start practicing now. So when exam time comes, it won't be something new to you. It won't be trying to learn it in like the last week. You've have been introduced to it, and will know it. So that'll be next week in skills. This week was about evidence and policy because it seemed to be a hot topic going forward. So again, you guys can email me with any questions, and I will be speaking to you later. So thanks again for watching.